Or who is taking the lead now?
So that's me.
Okay, excellent. I don't dare pronounce your name, but
Okay, it's Polaszek.
Polaszek.
Yes,
Okay.
thank you.
I wouldn't ask you to pronounce mine. So I mean, well, we're even here.
Okay, well, thank you, and I will present TECO's closing on damages. So first, we will cover the typo in the transcript and at paragraph 97 of the resubmission award. Okay, and so this is the exchange 27, yes. And so this is the exchange between Professor Lowe and Mr. Blackaby, Guatemala's counsel, at the close of the resubmission hearing. And Guatemala suggested today, I think for the first time, that this exchange related to a hypothetical scenario where the sale of EXA is assumed away. And they said that this is because the question by Professor Lowe had this part of the sentence where it refers to, I quote, not simply to 2010, without any reference to the sale price of EXA, unquote. So based on that, they were suggesting that he was not asking about anything else but a hypothetical scenario where we assume EXA sale away, and in that scenario, wouldn't we carry forward the whole calculation into 2013? And that's just not a supportable interpretation, because in the arbitration, it was TECO's position that the actual sales price of EXA should not be used as the basis to calculate the damages. Mr. Kaczmarek used other methods. This is explained in the pleadings. We might have mentioned it yesterday. And so this reference to the sale price of EXA, that's not asking about some hypothetical scenario where there is no sale of EXA. Such question would not make sense anyway in the context of the hearing. And as you can see, it is not about the sale or not sale of EXA. It is about the sale price of EXA. That's a difference. And Guatemala also mentioned in its closing, this was at slide 87 today, that on day one of the resubmission hearing.
Sorry, Mr.
Yes.
Polaszek.
Yes.
Polaszek. What does it mean then, without any reference to the sales price of EXA? What do you understand this to imply?
I read that as a reference to TECO's position that the damages should not be calculated based on the sale price of EXA. There was a debate on that. Dr. Abdallah did use EXA sale price to calculate damages. He got the range of actual values based on that.
So it's on the actual value.
That's the way to read it. And I think also in context there would be no point to be asking a question like this at that point of the hearing.
Thank you.
Okay, so just briefly at slide 87 of Guatemala's closing, Guatemala referred to the statement of its counsel at the resubmission hearing on day one of the hearing, to the effect that calculating the loss of value damages was not a simple mathematical exercise, and that the tribunal could not simply take the historical damages calculation and project them forward. So I want to point out again, that was the first day of the hearing. That was at the beginning. After hearing all the evidence, Professor Lowe asked this question, which we see on slide 27 of TECO's closing slides. And this is at the end of the hearing, day 4. And this was Guatemala's answer at that point. Moving to another topic. So also in its closing, Guatemala at slide 110 cited Dr. Alexandrov's statement at the resubmission hearing that Dr. Abdallah's criticism of the but-for value should be discussed more at the hearing so that the tribunal understands them better and can rule on them. And also, Guatemala cited Professor Lowe's statement that these are among the points that the tribunal would like to hear more about. And as I showed you yesterday, that's exactly what happened at the hearing. This was discussed between the tribunal and the experts. And this is at TECO's opening slides 99 and 100. And as I showed you yesterday in those discussions with the tribunal, Dr. Abdallah conceded with respect to one of his criticisms. This was the issue of cash flows to equity versus cash flows to the firm. That criticism of his was inconsistent with the future, with the actual sale of TECO to the company that held EXA among other assets. And so, as I pointed out, Dr. Abdallah basically gave up that criticism. Today, Guatemala had no response to that. They said nothing. They focused instead of two other criticisms that were also presented by Dr. Abdallah. One relates to the elasticity of the demand, and the other one to inflation. And they showed this on slide 113 of their closing statement. And they suggested that because the resubmission tribunal did not elaborate this in the award, this was somehow a failure to state reasons and a serious departure from a fundamental rule of procedure. So just so that yes.
If I may.
Yes.
There was just a statement 30 seconds ago. It took me 30 seconds to go through this statement again to review that I was interrupting in vain. But Mr. Polashek says that Mr. Abdallah agrees that he gave up on that criticism, or agreed that that criticism was inconsistent with the future. He did not point to any particular point of any transcript. I was going through the slide 100 on the opening presentation of yesterday, which is where we had taken the attention from. We don't see that text. If ever those words were uttered, we would really like to see where that was said. Or otherwise, if this text is on 100, we would kindly ask not to misrepresent the testimony of Mr. Abdallah as shown in the slide that TECO showed.
So, if I may respond to that, I was referring to the slide that was before the committee yesterday. I don't have it right now, but it is slide 100, and I think the committee can read for itself that portion of the transcript and around that section in the transcript itself, if it wishes to look into this further. My point was simply that I made this point yesterday, and Guatemala did not say anything about it today. They did not come back, and they did not say that I was wrong. They raise it now, but in their closing they did not. So
now we've got the slide 100 displayed there.
right.
So there were four issues. One whether the cash flows were to equity, right? So that was the first one.
Yes. So if I may continue, the cash flows to the equity holder, that's on the left hand of the slide, and on slide 113 in Guatemala's presentation today, they focused on the elasticity of demand and inflation. And so I just wanted to point out with respect to these criticisms that the first one, inflation, and this is explained at Mr. Kaczmarek's fourth report, paragraph 144, would have increased damages by 3.8 million. And the inflation adjustment, the elasticity of demand adjustment would have reduced damages by 3.7 million. So these adjustments were basically going in the opposite direction, basically offset one another out. That was referred to at the hearing as being washed out. And Dr. Abdallah agreed that his adjustments would wash out in this way. With respect to actual value, so also in its closing at slide 65, Guatemala suggested that Mr. Kaczmarek himself accepted that the actual value was a decisive question or had significant impact. And Guatemala cited to a place, I think it was reproduced on the slide, where Mr. Kaczmarek mentioned that depending on which actual value of EXA is used, there would be a difference to damages of 10.7 million or 15.6 million. So I just wanted to mention that both of these adjustments would have been to increase damages, as Mr. Kaczmarek explains there. And also this difference, these two numbers would have resulted from or would only arise if one were to accept the entire damages claim as presented. So this was not about the remainder of the 2008 to 2013 tariff period. This related to the entire claim. So the impact that Mr. Kaczmarek was quantifying there was on the 220 million plus that TECO presented. Couple of points about res judicata. So in the res judicata section of the award, the resubmission tribunal is not assessing whether for purposes of its own analysis of damages, the evidence before the original tribunal was sufficient or not. There was a lot of discussion about that at this hearing. Again, this morning we heard a lot about it. I think again the committee can read that section of the resubmission award for itself. And when you do, you will see that it uses words such as theoretically. In theory, it cannot be assumed, and it says that other factors might impact the original tribunal's conclusion if they had been taken into account by the original tribunal. And that's because all that the resubmission tribunal is doing there is assessing whether the original tribunal's decisions on historical damages had the effect of res judicata with respect to loss of value damages. Guatemala attempts to read two premises into that section of the award. Again, as I've shown yesterday, they are not there. The analysis of quantum is provided in a separate section of the resubmission award. I would also note that to the extent that there is any doubt on this point, and also to the extent that the committee concludes that there is an apparent contradiction in the resubmission tribunal's reasoning, which in our submission there is not. But even if this were the committee's conclusion, then the jurisprudence shows that to the extent possible, or as far as possible, the committee should interpret the reasoning in a way to find consistency and to avoid a finding of a contradiction. And you can see the authorities in TECO's opening slide 78 from yesterday. We did not have the time to go through that, but you'll see CDC v. Seychelles, Alapli v. Turkey, Malicorp v. Egypt. All of those committees made statements to that effect.
will you show us how the cash flows were calculated from 2010 up to 2013? Will that be part of your presentation?
So I can cover it briefly. That was your question from yesterday, and so in short, Mr. Kaczmarek took the same calculation or relied on the same calculation as he had presented in the original arbitration. He considered that that calculation was still valid. So he presented that same valuation before the resubmission tribunal. There was no change. There was a debate in the resubmission arbitration about Dr. Abdallah's criticisms. Those were considered. Mr. Kaczmarek responded to them in his fourth report. Fourth report. Then it was discussed again as the hearing, as I mentioned. But it is basically the same calculation that was presented in the original arbitration that Mr. Kaczmarek presented.
Okay, but that's not my question. The question is, how were they calculated? I know
how were they calculated?
The same way,
yes,
they
okay.
were the same.
So there was a valuation date of the sale of TECO 2, which included EXA among other assets. That was on. And that was
Forget
on
the discounting part. I just want to see how the cash flows projections were made.
Yes. So looking at the valuation date, there were historical cash flows, actual historical cash flows up to that date, up to the valuation date.
Correct.
So those were used to calculate the historical damages, though I think the important thing to keep in mind is that the relevant part of the tariff is set in 2008 for the entire tariff period. So basically what the company is earning, that is set for the whole 5 years at the beginning. It's set and it stays that way. So that's true in the actual scenario, and that's also true in the but-for scenario. There is no readjustment in either of the two scenarios throughout. That's, I think, a very important point to keep in mind. So then we have the actual company's performance through the valuation date. We have financial statements. That is the basis for historical damages. As of the October 2010 sales date, we take that and we project until the end of the tariff period, and that is the loss of value damages. Both parties did it that way.
Yes, and I'd like to know how that projection was made. Was it projecting the cash flows from the past, and then you increase them by a growth number, or is it exactly the same and you don't assume that there are other expenses? It's going to be
you project them for the rest of the tariff period, but you already know how you did up until to the middle of the tariff period, because you have the real life data for that. Yeah, and yes, we can come back tomorrow and maybe elaborate this a little.
So the thing is, just imagine I had no information about what occurred between 2010 and 2013, but I knew exactly what had happened between 2008 and 2010. Just having that data, would have been possible to project the 2010-2013 cash flows in a but-for scenario? Would have been possible, which is, I think, that was your proposition in the resubmission proceedings. We don't need more reports because we've got all the information about the historical damage. I don't think you even said about the data. You said data in the future, data between 2010-2013. I think you said, knowing the historical damages calculations, we only need to make a couple of arithmetical tweaks, and then we will know how much it will be for the next period. I think that was your submission, and I don't know if I'm oversimplifying what you said.
So and we'd like to reserve the right to elaborate tomorrow with more specificity, because yes, in the actual scenario, there are adjustments for inflation projections, things like that. For the but-for scenario, it's based on the VAD study. So in the VAD study, you're making those projections as well. And and it was an integrated model. That's the other thing, that the reason why we said it was an arithmetical change or adjustment was that we had the actual, the historical data, and then there were inflation adjustments, and also for growth of demand, there were, adjustments like that, and that's forecasted out. And then for the but-for, you have that VAD study, and then you do the same type of adjustments to that. You're just starting at a higher level for that. And what we had said was the tribunal then went through the inputs into that model and the original tribunal accepted Mr. Kazmarek's inputs. So we had argued, because in the original tribunal, we did not break out our damages as here is for the first tariff period, here's for the remainder. It was just, here are our damages. It just happened that we had a valuation date as of the date we submitted the claim to arbitration. So once we said, you looked at each of the inputs and you decided that our inputs were correct, it's an integrated model. That's why we had argued it's essentially res judicata, and they've accepted the model. Now they broke it off when they awarded us damages. You have the spreadsheet, you just go forward. The resubmission tribunal said, no, we're not going to accept that, because even though they said they accepted all of the inputs, they expressly rejected the damages from 2010 forward. So we're going to look at it, afresh. And then they looked at and determined, what was the actual and but-for value, as Mr. Palachik has been explaining. But we can tell you with more specificity exactly what, if this was your question, exactly what adjustments are made when you're forecasting going forward. Like, I know there was an inflation adjustment. I don't remember right now at what level or where they took that from, and also for demand. And we can tell you that if that assists, and also what Guatemala's view on those projections were, or how they adjusted. But again, they did not ever present their own DCF model. So what they did instead was just to offer criticisms to Navigant's model on things of this nature, like that we're discussing now. And those were new criticisms that, even though it was the same model in the original arbitration, these things that we're talking about with cash flows to the firm versus cash flows to the shareholder and elasticity of demand, those weren't raised in the original arbitration. It's just that after we went to resubmission, they came up with new arguments, new criticisms against that same model. And that was what was debated in the later reports.
Yes, I think some specific questions from the committee will come. So that